Yes, Miss Sano.
My Lords, I have here with Professor Douglas, KC, Kate Cook and Gayatri Sarati for the claimant, instructed by Rowan Smith of Lee Day. The respondents are represented by Sir James Eady, KC, Richard Honey, KC, Holly Higgins and Connor Fegan. And Total Energies and Total Financing appear as interested parties and are represented by Adam Heppenstall, KC, and Freya Foster.
Thank you.
You should have skeletons from all of us and supplementary skeletons from the claimants and the respondents. You should have a core bundle and a supplementary bundle, plus, I'm afraid, 2 further supplementary bundles. And you should also have received, my Lords, a Word copy of our skeleton that includes 2 corrections to the original supplementary skeleton. One is important, and that's footnote 1. Something went wrong there. The other is a few words that were lost, which made paragraph 45 no longer make sense. But just in case you haven't replaced it, I would just like to emphasize in particular footnote 1 and paragraph 45.
Footnote 1.
An incorrect reference had gone in there. The wrong point was being made in the footnote, so that's why it matters.
Well, I hope I've got the right skeleton.
You should have a Word version with the correct.
It says replacement skeleton argument for the appellant.
I'm talking about the supplementary skeleton.
Ah, sorry. Okay. Lovely. All right.
And of course, you have 4 bundles of authorities. Yes. Now, we added some points at the end of the authorities bundle that would more naturally have been in the supplementary bundle, but we didn't want to mess up the numbering.
Yes, well, let's worry about that when we get there.
I hope it will run smoothly enough, and apologies that it's not been perfect.
Have you agreed with your colleagues a timetable?
Yes.
What is it?
We have agreed that I am aiming for lunchtime tomorrow to finish. Then the respondent will have until lunchtime the following day, if I recall correctly. Then the interested parties will have an hour or an hour and a half, is it? And then I will have a reply. I have said that it depends. It may be that, bearing in mind what happened in the court below, it'll require me pushing to 3 on the second day.
What happened in the court below?
In the court below, what happened was that I had to cut short my submissions because I didn't stay within the timetable. But then what happened was that the respondents were shorter, so I ended up having a very extended reply. So it was rather unfortunate that it didn't quite work out.
Heaven forfend, I was hoping we might finish in a shorter time than 3 days. You don't think that's very likely?
No, my lord, I'm afraid I don't.
Okay, even if we stay very quiet?
Well, if you stay very quiet, we may. It depends, of course. It was very interventionist below, so there was a lot of discussion between the bench and the advocates.
This is a very quiet court.
So, my lords, to outline how we are going to take our submissions. First, I'm going to make some introductory contextual remarks. Secondly, Professor Douglas is going to deal with treaty implementation, interpretation, and how you go about your role in interpreting the Paris Agreement in order to give it effect. Third, Professor Douglas is going to deal with ground 2 of the appeal and the respondent's cross-appeal. That is the idea that you should apply a tenability threshold in determining whether the respondents misdirected themselves as to the law, and Professor Douglas will submit that this is wrong, contrary to binding authority on this court, and unworkable. Fourth, I will outline the background to unpotted history of the Paris Agreement, and crucially its scientific basis, before going on to deal with its meaning and effect, and our submission that Mrs. Justice Thornton correctly interpreted its provisions. Fifth, I will make submissions in relation to ground 3, namely that the respondents erred in law in concluding that the decision was compatible with the United Kingdom's commitments under the Paris Agreement. I will submit, my lords, that Lord Justice Stuart-Smith erred in finding that the UK financing a project which will result in an aggregate increase in global emissions that is not in line with the low emissions pathway provided in Article 2.1c of the Paris Agreement is nonetheless compatible with its obligations. Lord Justice Stuart-Smith was only able to find this on the erroneous basis that the Paris Agreement, to quote, contains a composite package of aims and aspirations that in this case are in tension and irreconcilable. That's at paragraph 231. I will submit that Lord Justice Stuart-Smith's interpretation is impermissible under the Vienna Convention on the Law of Treaties, and if upheld, would destroy the Paris Agreement. By contrast, Mrs. Justice Thornton's approach was correct. She properly applied the Vienna Convention to give to its terms effect in order to achieve its object and purpose. Sixth, I will deal with ground one of the grounds of appeal, namely the Tameside argument, and submit that again Mrs. Justice Thornton was absolutely right in her analysis and Lord Justice Stuart-Smith was wrong. I should perhaps explain this order.
Excuse me, I caught my breath. Sorry, just give me a second, Miss Simon. It's not your submissions. Keep going.
I should perhaps explain this order. So normally I would start with a decision before moving on to show why it did not reach with regard to the necessary relevant material considerations, and secondly that it was based on an error of law, namely that financing is compatible with the UK's obligations under the Paris Agreement. However, the facts, as now confirmed before this case, before this court by the respondents and in the judgment below, are that the respondents accept, first, that this project will lead to an aggregate increase in global emissions of global significance. And you can find that also in the judgment of Mrs. Justice Thornton, who sets out the evidence. And they accept that it will have a significant climate change impact, necessarily, therefore, frustrating the need for immediate cuts to global emissions if the temperature limits are not to be exceeded. In the court below, we argued by reference to the evidence that that was the case. The respondents never accepted that contention. We understood the summary grounds of defence, paragraph 47.3 in particular, which is at core bundle 20, and paragraph 75.3 of the detailed grounds of defence, which is at core bundle 15, to say that the respondents considered the project would lead to a net reduction in future emissions, albeit that we ourselves pointed out that the climate change report did not in substance appear to say that. You have the annex to the supplementary skeleton, which shows the lack of clarity. The language used is always net reduction. There is no mention of the word increase at all, let alone net increase or aggregate increase. Nonetheless, my lords, none of that matters before this court, save to expose a certain lack of clarity and transparency in the thinking, analysis and presentation of the decision. What matters before this court is that the respondents accept that the project will lead to a significant aggregate increase in global emissions. Based on back-of-the-envelope calculation by Bayes, with caveats that exclude transport and methane, the emissions amount to 1.13 gigatons of carbon dioxide, so not carbon dioxide equivalent, it may be higher, over the lifetime of the project.
So 1.3...
1.13, and you find that in core bundle tab 45.
Do you want us to go there now?
No, my
This is all introductory at the moment.
This is all, I'm afraid, introductory, yes. I will come to the detail when I deal with it. Now, it's an extremely significant quantity when looked at in the light of the remaining carbon budget of 420 gigatons. That's a finite remaining budget. it amounts to 0.27% of that budget. You'll see that Mrs. Justice Thornton said almost 2%, but what she didn't calculate, or didn't add into that calculation, was scope 1 and 2 emissions. So she based that on the 800 million tonnes of carbon dioxide from scope 3. You don't need to worry about this at the moment. My main point is that we know that there is going to be a significant increase, and that is accepted by the respondents. They say that some of the LNG could displace existing fossil fuels or new fossil fuels coming on stream. But, my lords, that would only slow the speed at which greenhouse gases concentration in the atmosphere increases.
I mean, do you accept that it could replace other more polluting fossil fuels?
Yes, but the effect of that would simply be to slow down the amount. The amount that would enter the atmosphere would be the same.
I mean, how do we know that the effect would only be to slow down?
Because of the very simple law of physics, that if you burn carbon, some fossil fuels have a higher emission percentage than other carbon fuels, but ultimately, if this liquid natural gas is used to create energy, the amount of greenhouse gases it emits is a calculable number.
I mean, can I just put this to you, because I once did some physics.
Probably more than me.
It was a very long time ago. But if the emissions from burning coal are, say, 50%, 30% more than from burning liquefied gas, and every ton of gas, the thermal equivalent of every ton of gas, was used to replace the use of coal, surely this project would reduce emissions. I realise that may be very unlikely, but if it happened, it would reduce emissions, right?
If the only thing that's being used is coal, and the emissions on coal are, say, predicted
Well, say they're this high.
Say they're this high, then it would be this high, that's right. If they're like this, then it just will slow the curve down slightly. But in the end, we're still going to have 800 million tonnes from this.
Yes, but this discussion may be relevant to the temperature increase goals in the Paris Agreement, because there is a time dimension, and that is what my lord is driving at with his question.
That's
correct,
right,
isn't
and
it? That is basic physics, actually.
That's right, and what we haven't been told is anything about the curve. So there is no. It is accepted on the other side that there is an aggregate increase.
But the Paris Agreement does not say we will all stop burning coal or we will all stop burning fossil fuels. That's not what the Paris Agreement
says. No, that's
right.
And my lord, I will not be submitting that it says that. So the question then for this court, we say, in relation to ground 3, is whether it is correct that the UK can finance a project which, on the respondent's own case, is not consistent with a pathway to low greenhouse gas emissions and still act compatibly with the UK's obligations under the Paris Agreement. The respondents say that they can for one simple reason. Their claim that Mozambique has said that it would be good for Mozambique's development. And our submission is that it plainly cannot. Accordingly, we say the decision was taken on the basis of a misdirection of law.
So your submission, I didn't get that. Your submission is what plainly?
That you can't say we can increase emissions inconsistently with the pathway if the country says it'll be good for development. So we say the decision was taken on the basis of a misdirection on law. We also say it was based on a misdirection as to facts, because the decision was based on the argument or statement that it was not possible to quantify scope 3 emissions.
I mean, just to be clear, Ms. Seymour, you obviously would accept, wouldn't you, that this project would be good for the economy of Mozambique. and the standard of living of the inhabitants of Mozambique. Would you not?
No,
No, you don't.
we don't accept that. We don't have...
I'm not talking about the climate change effects. I'm talking about the economic effects.
my lord, I will make my submissions on that, and we'll also hand you up a note coming from the documents that are in there in relation to the finance of this project, because of course these things are not quite as simple as they sound in terms of loans, debts, and risks.
Sorry, you haven't answered my lord's question, I think. Do you accept that the project is economically beneficial to Mozambique?
My lord, we cannot dispute in front of this court the specific numbers in terms of dollars that it has been claimed will Mozambique will benefit. So I believe it's around 50 billion, 50 to 60 billion. In terms of economic benefits for Mozambique itself, my lord, we do not accept that it is not actually something that is an issue in this case. It was never put in issue below because it was never part of the case. So we don't have any evidence on it, nor do we have. It wasn't something that was in dispute because it was not. The case was argued so differently below. So it's only now that it's being said that you can have a pathway that doesn't fit 2(1)(c) if it's for economic benefit. And so it's taken on a different role in this court. There are certainly, we had before the divisional court, we did put an E3G report, which we can provide.
You're going to have to use less acronyms for me.
Unfortunately, that it's a think tank that is used quite extensively also by the government, which has looked at the effect of gas on Mozambique's economy. So at the end of the hearing,
that's
because
an E3G report.
E3G, we will give you copies. At the end of the hearing, what happened was the interested party handed up a report from the Tony Blair Foundation about gas in Mozambique, and we provided this report in response. But it is certainly in dispute that this development will benefit Mozambique economically. So finally, we say it's vitiated by illegality since its conclusions on climate impact and compatibility with the Paris Agreement were material to the decision, even if not determinative, and didn't consider quantification. Now, we submit Mrs. Justice Thornton was right in her judgment, and we commend her judgment to you and seek, my lords, to uphold that judgment.
It has the great benefit of being short.
We emphasise that neither one nor other of the judgment in the divisional court has greater weight. There is no judicial hierarchy in the divisional court. There is not, therefore, a judgment and the judgment and a dissent. Rather, there are two judgments in which the judges sitting in the same division reached opposite conclusions. There was a straight draw below. Because of the rules of court, however, and the need for an order, the appellants took the pragmatic decision to proceed.
What is the rule? I'm sorry, Miss Samuel, but this slightly intrigued me because I hadn't come across it before. If a divisional court sits and one judge, whether it's the senior judge or the junior judge, doesn't seem to matter, they reach opposite conclusions, the application fails. Is that right?
No, my lord. That is, there was no authority for what happened below. What happened was that the judges could not agree and therefore said that we had to have the case reheard.
I thought they offered you the...
Rather, they offered us, or they said it needed to be relisted.
Well, there's a statutory right, isn't there, to have a decision of an evenly divided court re-argued before a differently constituted court.
Oh, there may be.
But you all took, if I may say so, the very sensible decision that you might as well come straight to us.
Well, it didn't seem to us sensible to have another divisional court hearing.
But we're sitting as the Court of Appeal.
Yes.
Yeah.
Hearing an appeal against what?
Well, you're hearing an appeal against the order. The only reason that we proceeded in this way was to allow there to be an order that dismissed our claim. Because you can only appeal against an order. So
Yes, I know, but the question that I was asking, which sounds quite naive, perhaps, for the Master of the Rolls to ask, is why was the order against you if there was an evenly divided court?
because we took a pragmatic decision to accept that approach.
Well, what I mean,
Well,
the court made the order, not you.
Yes, but the only precedent that we could find was the Privacy International case, in which Lord Justice Leggett actually did something rather different to what Mrs. Justice Thornton did. He effectively said, I don't really agree with all of this, but I'm willing to agree in order that the order can be made so that it can go to appeal because it doesn't really matter. And ultimately that case went to the Supreme Court. What Mrs. Justice Thornton didn't do in her judgment was say, I agree for the purposes of the order. So this is unprecedented, put it that way. And my only point before you is that there is no reason for you to consider that there is the judgment and the dissent.
I mean, look, you're pushing it in open door as far as that's concerned with me anyway, but I would like somebody to tell me what the statute my Lord is talking about, if there is one, and what the formal position is when a two-judge divisional court reaches opposite conclusions, so that the judgment 1 would lead to an application dismissing the application, and judgment 2 would lead to a declaration of some particular relief. Why does judgment 1, why does the court make the first rather than the second? I assumed the reason was because an application doesn't succeed if the court is split. That's what I assumed, but I haven't met
my Lord,
it
I
before.
do vaguely recall Lord Justice Bean's point that there is a right of rehearing. We objected considerably to a rehearing and even suggested that
you're sorry, I don't want to, we don't need to spend a lot of time on this, but the right of rehearing arises after you have failed to get the relief you wanted from the two-judge court. All I'm driving at is, what is the reason why you failed to get the relief you wanted from the two-judge court when you have one judge on your side? Answer, I think you don't get relief if you haven't got a majority in the court.
There was no authority for that.
Well, okay. Well,
We looked in detail at all the authorities on this, and the only way to have got a majority, we would have had to have had a rehearing. Yeah. So it was a pragmatic decision to accept an order against us.
I think you're saying the same thing.
Yeah.
Yes.
I mean, as a matter of fact, the order states the claimant's claim for judicial review is dismissed.
Exactly.
That's what the order states.
That's my point.
Yeah.
Exactly. Exactly.
Yeah, okay.
But we just didn't think it was worth arguing that actually it shouldn't be dismissed because we needed to get in front of
But the
the court.
court decided to dismiss it, and you are not saying that that was the wrong decision, simply because of Mrs. Justice Thornton's judgment. You are saying you declined to take up the offer of a rehearing, which was statutory, to which you were statutorily entitled. My Lord is now finding the statutory entitlement, but he can let counsel do that. There are juniors in court who would love to have that as a project, and all we need to know is that I would like at some point to know whether there is any reason why the court was bound to dismiss when you had failed to take up the offer of a...
Well, my Lord, I can answer you that. As far as we know, and we did do research into the authorities, there is no reason.
There is no...
No reason. We could equally have one, and the respondents could have been the appellants. Could have gone either. They could have done either. There's no authority for this.
Right, okay. Well, there may be after this case.
Now, we submit that Lord Justice Stewart went seriously wrong and that his judgment creates a precedent that blows a hole through the Paris Agreement. If he's right, the Paris Agreement allows international energy companies to exploit fossil fuel reserves in developing countries and to do so with finance from developed state parties, export credit agencies, sovereign wealth funds, etc. On the respondent's case, to do so, all that is needed is to show that a small percentage of the revenue from that exploitation will end up in the developing country, and that the developing country says that that will be good for its economy. And if that were correct, there would be no point in any state reducing its emissions for climate change purposes. Put another way, there would be no point in any state abiding by its commitments under the Paris Agreement, and no state would. That is because emissions from such reserves would make it impossible to meet the temperature goal. That being so, there would be no point in the United Kingdom or any other country spending money to become net zero, save of course for the new motivating factor of energy security. The reason why the Paris Agreement was such a landmark is that by it, all countries committed to take ambitious efforts to achieve the temperature goals. That itself is a necessary and essential basis for climate resilient development. It was an enormous leap from Kyoto, where only developed countries were bound to take action. And no party will act unless there is good faith and trust that other parties will stick to the agreement. In fact, the United Kingdom ended finance for fossil fuels from CDC, now the British International Investment, the day of the operative decision, 1 July 2020, in order to align with the Paris Agreement, and through UKEF 6 months later. The UK has recognised that it has committed to do that under the Paris Agreement and now includes it in its NDC, which I will take you to. The finance decision here was no more compatible with the Paris Agreement commitments on 30 June than it was on the 1st of July 2020. It seems that ministers required to be reassured that the finance was compatible with the Paris Agreement and were reassured, but that reassurance was erroneous. It was a misdirection of law. Now, my Lord, I'm going to make some contextual remarks about climate change. Climate change has become the ultimate limiting factor in human endeavour. It impacts food, water, energy, health, and causes migration, conflict, and wars. It is a global problem caused by the emission of man-made greenhouse gases into the atmosphere. These gases, which include nitrous oxide, carbon dioxide, methane, and other gases, exist naturally in the atmosphere and are needed to retain heat from the sun so as to make this Earth sufficiently warm to be habitable. In fact, the natural gases keep the Earth at about 30 degrees warmer than it would otherwise be. However, man's addition of these gases into the atmosphere by burning fossil fuels has created and is creating an ever more impenetrable layer through which radiation from the sun, which is reflected back from the Earth at different wavelengths from when it enters, cannot escape into the outer atmosphere. As that layer becomes increasingly concentrated, less and less heat can leave the atmosphere, causing an increase in global temperatures. Man-made emissions have caused carbon dioxide concentrations on Earth to increase by about 30% since pre-industrial times, and there is a direct linear relationship between that concentration and temperature rises. The Earth's temperature has increased by about 1 degree since pre-industrial times. Now, a very helpful explanation of climate change, my lords, and the implications is set out in the Sharma case. It's a Court of Australia, Federal Court of Australia case. And for your note, it's Authority Bundle 4, tab 49, page 2799, paragraph 37 to paragraph 73. When the science of global warming was first understood, now more than 70 years ago, historical responsibility for man-made emissions still lay predominantly with Western industrialized economies, countries that had become wealthy through the burning of fossil fuels. That has changed, my lords, in the last 20 years, with China in 2007 contributing more greenhouse gases than the USA, and in 2012 more than the USA and the EU combined. And I will come to the relevance of this in a moment. The effect of this warming has differentiated local impacts, with droughts, floods, heat waves varying across geographies and differing in scale. But these globally differentiated impacts occur irrespective of where the emissions take place. They are greatest in the poorest countries, in particular the global south, albeit that they are now impacting everywhere, including in Western Europe. Mozambique, my lords, is one of the most vulnerable countries in the world to climate change. Climate-related hazards such as droughts, floods and cyclones are occurring with increasing frequency, which is having a cumulative and devastating impact in terms of life and economy. Central Mozambique is projected to experience recurrent agricultural losses as a result of droughts, floods, uncontrolled bushfires. The densely populated coastal lowlands will be increasingly affected by severe erosion, saltwater intrusion, loss of vital infrastructure, and the spread of disease such as malaria, cholera, and influenza. Changing rainfall patterns will lead to a decrease in soil water recharge, impacting groundwater resources and the water table in wells. Reduction of Mozambique's transboundary river flows will decrease the availability of surface water, and average annual rainfall has decreased significantly at a rate of 3.1% per decade between 1960 and 2006. At the same time, my lords, the proportion of rain falling in heavy rain events has increased at a rate of 2.6% per decade. Mozambique's coastline is the third longest in Africa and is home to approximately 60% of the population. The south and coastal regions have experienced increasing rates of extreme events due to these changes in temperature and rainfall. The south has become hotter and drier and experiences more frequent and more persistent droughts, while coastal regions have faced more episodic floods. At the same time, a sea level rise of about 3 centimetres has been observed at Maputo between 1961 and 2001. Examples of cyclones, albeit that there have been more since, include Cyclone Idai and Cyclone Kenneth in 2019. 2.5 people as a result were in need of humanitarian services. 603 died. 1,641 were injured. 223,947 houses were destroyed. 160,927 people were displaced, and 715,378 hectares of crops were damaged. The painful irony at the heart of this case is that the development of the vast gas reserves on the coral and mangrove coast of Mozambique will result in an increase in global in GHG concentration that will impact most severely on Mozambique itself, exacerbating the rising sea levels, increasing infiltration of salt into rivers and groundwater, and creating more and more severe hurricanes, whilst producing vast revenues for corporates based in the developed world, including the first interested parties.
Was there evidence of that proposition?
There is
the greatest climate impact of this project would impact on Mozambique itself. There
is the evidence that I took you to comes from a World Bank report about Mozambique. The direct causal relationship between this amount of emissions and the effect of Mozambique on Mozambique. No, of course there is no evidence in relation to that because of the problem.
Well, I mean, it sounds a very serious submission. The greatest impact in terms of climate change of the emissions from this project will impact Mozambique. Is that the submission?
Yes, the Mozambique is in the table of countries affected by climate change, right up there at the top.
Yes, so what I don't understand is, I mean, I thought it was because of the perhaps scope 1 and 2 emissions rather than the scope 3 emissions, because the scope 3 emissions will be global, presumably, because the gas is going to be exported, but I don't know the figures.
But that's the point, my lord. That is actually the central point of this, is that what matters are the absolute emissions, scope 1, 2 and 3. Doesn't matter where they happen.
Right.
And there is no dispute, and there could not be any dispute, that Mozambique is one of the most vulnerable countries in the world to climate change.
Yes, but I mean, there's a difference between saying it's one of the most vulnerable countries to climate change and saying it will be the worst affected in the world by this project.
I should not have said it will be the worst. I should have said it will be one of the 5 or 10 worst.
And that's in the evidence, is it?
That specifically is not in the evidence.
Right. Well, what does the evidence say about this question?
There is no. There is evidence from the AFDB itself that I'll take you to, that talks about how the project itself will have to be built on high land because of hurricanes and all the rest of it. Below, we had a report from Netherlands. Unfortunately, this is rather unfortunate how this case has happened, because really we should just have the same bundles we had below. But there was a report from Netherlands on climate change impacts in Mozambique. Again, we can give that to you.
I mean, the reason why, the reason why I think this is important really is that, as I understand the respondent's case is that this is a project which is good for Mozambique in economic terms, and you have misinterpreted the Paris Agreement to suggest that it's all about really one provision, whereas the thing is much more nuanced than that and allows for developing economies to continue to exploit fossil fuels where it is good for their economy and development. It's not intended to make poor countries poorer, the Paris Agreement, and that this project would benefit Mozambique in a number of different economic ways. But what you're saying is it will actually, the benefits will be outweighed by the climate change effects on Mozambique itself. Now, I mean, you haven't used the word outweighed, but that's the way I sort of understood what you've just said. And if that's your case, I'd like to see the evidence for it.
My submission, because this has become a new argument, the UK Export Finance Department gives financing in order to secure contracts, essentially for British companies. That is its primary purpose, statutory purpose. Development finance was ruled out in this case, but also more generally for fossil fuels. This is not a development decision, and I will take you to that.
This is not a
development aid decision.
No.
I will take you to that. This is a decision by UCARE that 2,000 jobs will be secured in the United Kingdom, and that there will be a return for the Treasury.
Well, now, maybe not for now, but I think what goes to my Lord's point, which I'm interested in as well, is the question of what assessment was made, as it were, domestically of the impact of greenhouse gas emissions from this project on Mozambique itself. That, in a sense, is a missing element at the moment in the evidential picture, so far as I can see. And I'm quite interested to see what was done, if anything, to make that assessment. Whether it be, whether it be scope 1, scope 2 or scope 3 emissions, the effects on Mozambique itself, whether through an environmental impact assessment or equivalent, or how, is the question. Not for now, but I think at some point we need to be taken there.
So what there is, I can tell you straight away, is the African Development Bank looked at the effect of climate change in its review, and I will show you to that. But what it looked at is the effect of climate change on the project.
What did?
The African Development Bank.
African Development
Bank review. I'll take it to you. And what they looked at is how great the risk was to the infrastructure of the project. So it's a couple of paragraphs. It says, well, it's being built on high land, it's going to be cyclone proof, etc. what there was not, as far as I am aware, was a report on the climate change impact on Mozambique and the people of Mozambique.
Yes, it's the impact, if I may say, of the project, not on the project,
Exactly.
that we're concerned about.
Exactly.
On Mozambique.
Exactly.
Not for now, but at some point we need to be taken there. If you can.
Yes, just simply to say, and I'll take you to this, I'm going to now, DFID was against the project. Now, Carl Sagan, the renowned astrophysicist who contributed to so much to the science of global warming, gave evidence to US Congress 37 years ago, and he said, nations, to deal with this problem, have to make a change from their traditional concerns about themselves to concerns about the planet and the species, a change from short-term objective to longer-term objective. What is essential for this problem is a global consciousness, a view that transcends our exclusive identification with the generational and political groupings which by accident we have been born with. The solution to this problem requires a perspective that embraces the planet and the future, because we are all in this greenhouse together. Now, my lords, it took many years to move towards that change, that new perspective, and it remains a continuous struggle. Whilst it commenced with the Stockholm Declaration in 1972, it was only in 1992, with the agreement of the UN FCCC, that real progress was first made. From that time, there has been a progression of decisions, communications, declarations, and agreements, culminating in the treaty, the Paris Agreement, in 2015, where all parties, developing and developed countries, finally agreed to commit to achieving a specific binding temperature limit. Over those years, countries negotiated their apparently irreconcilable needs and the injustices of history and geography to reach a means to prevent the destruction of the planetary system by climate change. Those compromises, those trade-offs, are set out in the Paris Agreement. Certain elements, such as loss and damage or specific commitments to climate finance, continue to be negotiated at the annual COPs. But the core agreement, my lords, is there. The parties have all committed in Article 3 to take ambitious measures to achieve the objectives in Article 2, crucially, the temperature limit. As I will explain, the basis of the temperature limit was the knowledge that achieving it involved not exceeding a certain concentration of greenhouse gases in the atmosphere. The parties agreed, in effect, to limit emissions within what is an absolute and finite budget, which, if exceeded, will mean the temperature goal will not be met. And this is called the carbon budget, and it's explained by Mrs. Justice Thornton at paragraphs 252 to 253 of her judgment. The developed countries, my lords, agreed to take the lead, but crucially, developing countries also committed to those budgets. They did so on the basis that the developed world committed to support them with finance and technological transfers. And I want to make three crucial points about that. First, there can be no doubt that the parties to the Paris Agreement understood that they were committing to a radical reduction in emissions if the temperature limits were to be achieved. That was the explicit reason for the Paris Agreement, to provide enhanced, and that language is used, and strengthened, again, language used, the global response to the urgent threat of climate change. And I'll take you to the Durban Accords, where the decision to move forward to develop and agree a further treaty under the UNFCCC was made. In the decision adopting the Paris Agreement, the parties expressly noted the significant gap between the commitments that had been made and the emissions reductions that were needed to stay within the carbon budget. Again, the parties understood that they were committing to do more than set out in the state commitments to date in order to meet the temperature goals. And I will take you to the relevant parts of the decision by which the Paris Agreement was adopted to show you that. In it, the parties refer to the scientific evidence that emissions needed to be reduced to 40 gigatons per annum by 2030, around a 6% reduction per annum, and that on projections, assuming all reductions under commitments were made, emissions would still be 55 gigatons per annum. So the trajectory was up, and they knew it was up, and they committed to take it down. The decision noted that even greater reductions in emissions would be needed to meet 1.5 degrees, and that these would be identified in an IPCC report that would be published in 2018. And this became the central SR 1.5 report, which I will take you to. My second point is that the Paris Agreement was a recognition of the fact that individual state commitments to reduce emissions, as had existed under Kyoto, could not meet the UNFCCC objective of stabilizing emissions. Parties agreed that to achieve the necessary reductions with sufficient speed, a wholesale reorientation of finance was required, indeed of economies. And this is something, my lords, that is now well underway. The Paris Agreement set that core objective out in Article 2.1c. Article 2.1c thus represents a recognition by the parties that it is only through an urgent and wholesale reorientation of finance, investment, loans, guarantees, insurance, that the world can move to carbon neutrality, net zero, sufficiently swiftly to remain within the temperature limit, after which catastrophic and likely irreversible planetary harm will take place. Urgency, my lords, is at the heart of all of this, which is what Lord Justice Stuart-Smith ignored. And the UK is one of the key advocates and movers in this area, mandating reporting under the TCFT for portfolios, pensions, insurance, and pushing the city to align its finance with Paris. The third point, my lords, is there is no dichotomy or contradiction in the Paris Agreement between development and climate change. These are not contradictory objectives, but inherently linked, indeed interdependent. This case is concerned with compliance with international legal commitments and obligations agreed to by the global community, including the Global South, to safeguard to the greatest extent still possible the planetary system and life which depends on it. Put simply, there is no climate resilient, sustainable development unless global warming is kept below the Paris Agreement temperature limits. Indeed, that is the central concern of the Paris Agreement and the Sustainable Development Goals. And the UK itself signed up to a declaration to that effect at COP26 last year. Now, these 3 points are reflected in statements by the UK itself, starting with the Green Finance Strategy in 2019, the fact that official development assistance would be aligned with the Paris temperature goals. And if I can take you to the Green Finance Strategy, you find that in the 4th Authorities Bundle. At tab 60, right at the back.
Yes.
So we have the paragraph transforming the financial system.
Sorry, which page are you on?
Page 3329, it's the first page. I'm sorry, it's on a...
Well, that's a picture. Oh, I see. Okay, yep.
So you have transforming the financial system, and then...
Whose document is this?
This is the government. It's the Green Finance Strategy. It's 2019.
Which department?
Bays.
Okay.
So this was current at the time of the
Yes.
decision.
And then if you look at under greening finance, the transition to a green financial system means fundamental changes to the way decisions are made across the economy. To achieve the goals of the Paris Agreement and our wider environmental ambitions, all finance will need to incorporate the financial risks and opportunities presented by climate change and other environmental challenge. And then...
So what does that mean? What do you say that means?
There is
to
a
achieve the goals of the Paris Agreement and our wider environmental ambitions, all finance will need to incorporate the financial risks and opportunities presented by climate change. I mean, what is the sort of hard-edged consequence of that statement?
Well, this is an introductory statement. It's a
okay,
statement.
fine.
If we can go to then 3330.
Yeah.
Building on the UK's international...
Sorry, where?
Sorry, it's second column, halfway down, starting with building.
Yeah, got it.
Building on the UK's international experience, including the Bank of England's involvement in the Central Bank and Supervisors Network for greening the financial system, we will also use our influence to strive towards greening the global financial system. And then you have various initiatives by the UK which show its role in this. And then the last bullet, aligning the UK's official development assistance with the Paris Agreement.
What is official development assistance?
It is the money that comes from DFID, was DFID, I think it's now under the FCO.
Is that UK?
Yes, UK. No, it's not UKEF. So UKEF is UK Export Finance. It's run by the Department of Trade, and it's in order to secure jobs for British companies.
So this is nothing to do with UK.
No, this is development assistance.
Right,
So
okay.
we will align development assistance with the Paris Agreement. And then there's various other statements there about...
I mean, do you say this is... Sorry to interrupt. Do you say this document is government policy?
Yes. It is government policy.
Okay.
I mean, there isn't any dispute on that.
Well, I'm just thinking of the Heathrow case in the Supreme Court, and some of the comments of their lordships in that case about what is policy and what is not policy.
Well, the respondents will correct me if I'm wrong, but as I understand it, this is definitely government policy.
Okay, good.
And then 332, why finance is part of the solution.
It's not been changed, I take it, this.
No, this is still a live document. In fact, I will take you to documents from the CDC, which is now called British International Investment, which is another fund from the United Kingdom, which has also moved to this, and UKEF itself, since March 2021, also will not fund fossil fuels.
Also will not?
Fund fossil fuels. So fossil fuel funding by the United Kingdom is over. This was the last decision in which it will ever take place unless the policy changes, which we submit would be a breach of the Paris Agreement.
I mean, I'm just slightly puzzled by that. I mean, do we not use fossil fuels in the UK now? We do.
We do use fossil fuels.
Yes.
But
Well, therefore, they must be funded by somebody.
But the UK finance is not, as far as I know, and I couldn't say in relation to the North Sea, I do understand that under the windfall tax there is a tax break for North Sea investment, but I don't know whether that, and that may be subject to challenge at some point. My understanding is that the UK, so taxpayers' money, is not used, public money, sovereign wealth funds, etc., are not used to fund fossil fuels. That is UK policy.
Okay.
Again, if the respondents want to correct that, obviously that would be for
Well,
them.
let's keep going with this document.
So, page 3332, limiting global warming to 1.5 degrees may still be feasible. In the next decade, urgent, ambitious and concerted action is required across all countries and sectors globally to deliver emissions reductions, as well as directly remove some of the greenhouse gas from the atmosphere. So we need negative emission technology as well, or planting of forests. To do this requires unprecedented change in how we invest, measure risk and assign value to assets. The IPCC estimated that for a 1.5 degree trajectory, annual average investments in low carbon energy technologies and energy efficiency need to be upscaled by roughly a factor of 6 by 2050 compared to 2015, overtaking investment in fossil fuels globally by 2025. Recognising this need for urgent and coordinated action, 195 countries signed the Paris Climate Accord in 2015, which commits signatories to keeping a global temperature rise this century to well below 2 degrees above pre-industrial levels, and to pursue efforts to limit the temperature increase even further. Signatories of the Paris Agreement also committed to making finance flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. And then there's a comment starting from in recognition that this is part of government policy generally, and you'll see a chronology on the other page of what the United Kingdom has been doing, including the Chancellor's involvement in the establishment of the Green Finance Institute and the Green Finance Task Force. And then if we go to 3340, starting on the second page there, aligning the UK's official development assistance with the Paris Agreement. As the government explores initiatives to align global financial flows, we will be taking action to ensure government leads by example through aligning the UK's official development assistance spending with the Paris Agreement, strengthening the existing provisions in the UK government's guidance on considering climate change and environmental factors. In practical terms, this will include, and then second bullet, ensuring any investment support for fossil fuels affecting emissions is in line with the Paris Agreement temperature goals and transition plans. And then fourth bullet, ensuring that relevant programs do not undermine the ambition of countries' nationally determined contributions and adaptation plans. And then 2 paragraphs down, our actions to align the UK's ODA with the Paris Agreement also demonstrate the government's commitment to leading by example by integrating climate and environmental factors into financial decision-making in the public sector, as we discussed further below. And then 3345.
So this is important, is it, in your submissions? I mean, you say this is government policy that they will, in 2019, July, ensure any investment support for fossil fuels affecting emissions is in line with the Paris Agreement temperature goals and transition plans.
Yes.
And you say this is not.
Yes, and it's not in dispute, as far as I'm aware, that the respondents sought to do that.
No, but I mean, I'm trying to, we're looking at this document, it's quite a long document, but this is the first time I've seen something that would at first sight clearly state government policy to do something that is in conflict with what you say it did. I mean, am I building too much out of it?
Well, the factual position is that the respondents carried out an analysis, one we say was inadequate, in order to determine whether this was Paris Agreement compatible. their funding. They decided it was compatible, and on that basis, they provided the finance. So it was not that they were going against this policy. On the contrary, they just got it wrong. And then if we can turn to 3345. You'll see, and I take you to this because as a contextual point, it shows that everyone knows what the Paris Agreement really involves and requires. This is 3345 under driving international green investment. At least 6 trillion per annum of new or reallocated infrastructure investment up to 2030 will be required to meet the Paris Agreement and the wider Sustainable Development Goals. While this is a major challenge, it also represents economic opportunities. So there is a recognition of this complete reorientation of the finance system and economies generally.
Sorry, I was a bit behind you.
Sorry, it's
Miss
under...
Seymour. Is it 3345?
Yes, under driving international green investment.
Driving international.
Just a little paragraph under
I've got
that.
it, yeah. Thank you.
And the same is set out by the Department of Trade sector team report. In fact, this was an oil and gas team, which the decision maker says, the civil servant, Mr. Taylor, says he relied on and is referred to when advising the Chancellor. And I'm just going to take you to his report. It's in the supplementary bundle tab. Tab 32.
So just tell me what this report is.
So this is a document, the date of which is 24th April 2020. It is referred to in the statement of Mr. Taylor, who's the civil servant who appears to have run most of this decision making. And it's referred to in paragraph 65 of his witness statement.
Sorry, could you give me a page?
Sorry, it's 255. And it's got a bar chart graph on it. So you're on the right page.
This is DIT paper.
That's it. So you'll see in the second paragraph, just to describe what we just looked at, last year the Green Finance Strategy set out that UK ODA would be aligned with the Paris Agreement. This includes ensuring any investment support for fossil fuels affecting emissions is in line with the Paris temperature goals and transition plans. So that's what you just read. But this is a recognition of that by the oil and gas team in the Department of Trade.
By the oil and gas team.
Yes, they call it the sector team, but actually this was the oil and gas team writing this. I'm now going to take you to
And you say this was referred to at paragraph 65 by Mr. Taylor in his statement.
that's right.
Thank you.
That's at supplementary bundle, tab 60, page 472.
Sorry, supplemental bundle page
Tab 60, page 472.
472. Yep.
Now that is also reflected, what we've just seen in the Green Finance Strategy, by the fact that on the 1st of July 2020, the day the finance was agreed, or the day after, the CDC which is the Commonwealth Development Commission, now called the British International Investment. It's a development finance institute, again, British government, ended all finance for fossil fuel projects. You find in SB tab 50, page 383, the Guardian article announcing that, and in the tab after that, page 386, you find...
Sorry, I'm behind you again. What page is that?
Page 383.
In what?
SB.
Sorry,
Supplementary bundle.
383. Okay. Thank you. It's a lovely picture of a chimney belching out black smoke.
So that's just an article announcing, that was an announcement by, so the UK government has announced that. And then on page 386, you get the climate change strategy.
I mean, it says CDC Group's climate strategy will stop support for most polluting projects in developing countries.
I'll show you in the policy.
Okay.
If you go to 388.
So what is 386 now?
386 is the CDC, now BII, British International Investment, and it's their report about climate change finance. And at page 388, first column, starting with Asset Development Finance Institution. As a development finance institution, one of the most important questions this strategy has to answer is how do we support economic transformation and poverty reduction in a socially just manner that not only delivers on people's need for prosperity and improved living standards, but also builds the foundations for net zero emissions by 2050 and increased resilience. This strategy articulates how we will rise to the challenge to deliver coherently on the climate and development challenges by aligning to the goals of the Paris Agreement and deliver on all sustainable development goals. In short, how we will support clean, inclusive and resilient growth in Africa and Asia. So what does this mean in practice? Like any investor, we need to operate within the remaining global carbon budget to limit global warming to 1.5 degrees. Firstly, we'll transform our investment portfolio so that it will reach net zero by 2050. Secondly, we will make an investment only if it supports a country's unique plan to meet its ambition to become a net zero economy by 2050, a prerequisite to limit global temperature rises. And then skipping the next paragraph. Crucially, we will not make new investments, either directly or through a fund, in fossil fuel subsectors that we have classified as misaligned with the Paris Agreement. In the rare cases where we would consider making a fossil fuel-related investment beyond these subsectors, it would only be to support a country in its transition to net zero carbon future.
This was on the 1st of July,
That's
2020. Right. And had a draft of this document circulated at all by then?
No, I don't know.
This was the day after the decision challenge.
And then 390, just the same thing, second paragraph. We will operate within the remaining global carbon budget to limit global warming to 1.5 degrees. This is in line with 2.1a of the Paris Agreement, which requires all financial flows to be consistent with the goals of the Paris Agreement, including the need for investments that support climate resilience. And that's obviously important in the light of the way the respondents put their case. And then...
Sorry, I need a page number for that.
Sorry, that's page 390, under the second little heading.
Yes.
We will operate, just that block.
Yes, thank you.
And the last line of that.
Yeah.
And then there's interesting information in here, but I don't have time to take you to all of it. 393, I've got bracketed. Support for individual pathways, decarbonising our portfolio. 394 we will not, so it's the third little plus sign there on the left, right, the bottom left-hand corner. We will not make any new commitments, whether directly or indirectly, through funds and co-investments in subsectors that have classified as misaligned. And you'll see there's a footnote to the World Resources Institute research data. And just try and remember that for the moment. That shows fossil fuel projects as being misaligned. This covers the following subsectors. And then if you go to the bottom, it says standalone upstream gas exploration and production, as well as transport infrastructure. So that is classified by the World Resources Institute as misaligned with the Paris temperature goals. And I hope in my submissions you will see why that is the case.
Is this standalone upstream gas exploration?
Yes. Now, its guidance relating to power plants rather than gas reserve developments, which are misaligned, shows, moreover, that, contrary to UKEF's claim, individual projects can be assessed for Paris Agreement alignment. And that's in tab 56. You can just go to page 420.
Thank you.
And the reason I asked my lords to remember the World Resources Institute document is it is referred to here. So on paragraph 1.2.
Sorry, this is the guidance.
This is the guidance about gas power. So it's a later document. It's December 2020, 6 months after the decision. The CDC is not going to be funding fossil fuel developments. This is a document to give guidance as to when it will finance gas power, because there's plenty already of the fossil fuels, it's just the use of it. So overview, if we start with a key objective of the Paris Agreement is to hold the increase to about and to pursue outputs. This goal requires global CO2 emissions to be cut by 45% by 2030 and reach net zero by 2050. It demands a transformation of the global energy system and I emphasise, as recognised by Article 2.1c of the Paris Agreement, for financial flows to be directed towards low greenhouse gas emissions and resilient pathways. And then infrastructure investment decisions should therefore take into account whether they are consistent with the 1.5 degree temperature goal. Recent work by the World Resources Institute provides a framework for doing this. So you can assess a particular project. It provides 3 broad categories for infrastructure in relation to the Paris Agreement. Misaligned, and that was the gas that I showed you in the previous document, the footnote. So it's the same World Resources Institute. And then aligned, and then conditionally aligned. So that's when, and conditionally aligned are things like natural gas power plants, which can, in certain circumstances, be consistent. And then at the top of 1.3, we recognise that we must operate within the remaining global carbon budget to limit global rise in temperatures to 1.5 degrees. The change required to address the climate emergency is not incremental. Without a fundamental shift in how economies and sectors work, the 1.5 degree target will be breached as early as 2030. And then at 423, there is reference to the pathway in the penultimate paragraph. The IPCC identified the global, we've come across this already, the remaining budget 420 gigatons for a 2/3 chance of meeting 1.5 degrees. It also estimates that committed emissions, specifically associated with existing infrastructure, amounts to more than 2/3 off this budget. So we're way off the budget, implying very limited space for new fossil fuel infrastructure in Paris-aligned pathways. And this is in the context of the power plants, not the actual production of fossil fuels. In relation to the power sector, the IPC states that a robust feature of the 1.5 degree consistent pathways is virtually full decarbonisation of the power sector around mid-century. This is also a feature of the 2 degree consistent pathways, indicating that GHG emissions must be virtually eliminated from the global electricity system by 2050, regardless of the precise level of sub-2 degree warming targeted. This does not necessarily imply that gas is no longer used for power generation by 2050, but that it is deployed with carbon capture and storage. And then 424, you'll see, if you could just quickly read 2.4, which refers to nationally determined contributions. So, my lords,
Sorry, which passage was it on 424?
just the last one that says NDCs.
Yeah. And sorry, in there.
I need to go back.
Sorry.
All right.
Don't worry, I can find it. I'm sure.
It's 2.4.
Yeah,
I've
got that.
It's just to show that has to be
This is the NDC.
NDCs.
Thank you.
So if we can turn then to back to tab 54. We find there, that's page 412.
I mean, all this, except the green energy strategy, postdates the decision.
That's right.
So what do you say it adds to the green energy strategy?
My lord, our submission is that finance was no more aligned, finance for fossil fuels was no more aligned with the Paris Agreement on the 30th of June than it was on the 1st of July. And it doesn't matter whether you call it official development assistance or UK export finance. And indeed, if UK export finance could completely undermine the efforts of official development assistance or British international investment, it would be pretty pointless, those two funds operating in the way that they say they were going to, or are doing.
So I've written down, is this right, that your submission is that investment in fossil fuels was no more aligned with the Paris Agreement on the 30th of June than it was thereafter, as these documents show. So you say when the decision was taken that the investment was aligned with the Paris Agreement, it's in conflict with everything else government said thereafter, right? Is that the point?
That's right.
Well,
So it's in support of your ground 3, really, of your appeal.
Well, yes, our submission is that it was an error of law to tell the ministers that this financing was in alignment with the Paris Agreement.
I think there's an emphasis on immediately thereafter.
Yes.
The day after,
yes.
so the world has not changed dramatically in that 24 hours,
Yes.
I think lies behind your submission.
Well, yes.
Is that right?
Yes.
I mean, it's not that they weren't entitled to change the policy if they did on the 1st of July, it's that the realities manifest in the policy documents must have obtained in the relevant period for the decision making under challenge here.
Yes, indeed, the facts would have pertained certainly in 2018 at the time of SR 1.5, the IPCC report that showed the position, and the UNEP production and emission gaps reports that I'm going to take you to, because ultimately this is a question of numbers. So the factual position on alignment was likely the case in 2015 on the basis of AR5, which is the assessment report that preceded the Paris Agreement, but certainly the case by SR 1.5, which is the 2018 IPCC report, which set out what needed to be done and which is quoted from in those documents. So 6 months after the decision, the Prime Minister announced that UKEF, the first respondent, would also end financing for fossil fuels, again in order to align with the UK's commitments under the Paris Agreement, and you can find that at tab 54, page 412. And you find...
This was the 12th of December 2020.
That's right. And this had some coincidence with COP26. You'll recall that COP26 was postponed a year. It is quite possible in my submission that had COP26 not been postponed, this decision would have been made a year earlier. Now, my Lord, you find the actual policy at page 442. This document sets out what it's what the Prime Minister has announced. So he says, in a major policy shift, the PM will commit today to ending taxpayer support for fossil fuel projects overseas as soon as possible, as the government works to support the transition to a low
So
carbon.
that's suggesting that this is a policy shift at December 2020.
Well, because UKEF was not covered. Previously, it only
but I
been
mean, therefore, if UKEF's not covered, then your submission that it was covered before is depreciated, isn't it?
No, our submission is not that it was covered as a matter of government policy. Our submission is that it was an error of law for the ministers to be directed that the financing was in alignment with Paris.
Okay, so let me be clear. You do not say that the decision was in conflict with government policy. You, at the time, you say that the decision was not aligned with the... It was an error of law to say that the decision was aligned with the Paris Agreement when it wasn't.
Precisely. We say to finance the project would have been a breach of international law, which of course the respondents, as the executive, could perfectly, well, arguably I should say, have done. They could have decided that we will breach our obligations or commitments under the Paris Agreement by financing this project. But what they could not do is tell the world and the ministers who took this decision and the ERIC committee, which I will take you to, that this financing was compatible, aligned with the Paris Agreement goals. And the reason we are in this court, my Lord, and able to make this argument is because that direction was made. Otherwise, we would be standing in this court saying that the United Kingdom has breached international law, and my Lord would be telling me that I am not entitled to make that argument.
So you're here because the government said that it was doing something that was aligned with the Paris Agreement when it was not.
Exactly. We're in a Launder-Kebeline situation where we are saying that there was a misdirection as to law, and it happened to be international law.
And you say that's all demonstrated by the later documentation.
We say it's demonstrated by many things, but certainly this all helps to show that the UK itself thought it necessary to align all finance, and that involved ending funding for fossil fuels. And
so, I mean, this throws quite a lot of spotlight on the tenable, on the ground two, the tenable argument, because even if you're right about this point, if the other view was tenable and they're right on the second ground, then you still don't succeed, right?
even if they're right on tenable, yes.
If they're right on tenable, if you're right about this argument, in other words, that it is a breach of the climate, the Paris Agreement goals,
yes.
And they were in error in thinking it wasn't, they can still succeed if they show that all they have to have taken is a tenable view about the Paris Agreement meaning.
Yes, I mean, we say they won't succeed because
I understand
yes, of course.
Just,
if they can come up with a tenable if you consider that tenable is the right test, and if they can actually come up with what their tenable interpretation is, because we've not ever been told what their tenable interpretation is.
I'm sure, I'm very confident that Sir James will be telling me what their tenable interpretation is in due course. But
well, you say Mrs. Justice Thornton accepted that tenability is the test, but she still found for you on grounds 3 and 1.
We certainly do.
Is it to be inferred from that logic that whatever the government's position is, it's untenable?
Well, certainly.
That you do positively submit?
Yes, we certainly. We say two things. First of all, we say no interpretation has been put forward. But secondly, we say if the interpretation is the new one which is being put forward now, that development or economy, money, trumps climate, we say that's untenable. But that was not argued below.
Is your interpretation of Article 2.1c that nobody anywhere can start a new fossil fuel project full stop?
No, not start, because first of all, the parties are only states. So it's only states who are bound technically under the treaty, albeit that they are bound to influence private operators and act on private operators. And we will get onto this, and I am going to get worried about time in a minute, but certainly there are situations where, provided the fossil fuels were used in the particular country, there might be a different situation, a different balance. But I will take you to that when it comes to 4.1. But for the purposes, we certainly say that the opening up of vast fossil fuel reserves in developing countries for sale globally is impermissible, cannot be financed by parties, to the developed country parties to the Paris Agreement. Actually, any parties to the Paris Agreement. So just to turn then to this policy, you'll find the actual policy at page 442, which is tab 54. 8.
It starts on 440 actually, doesn't it?
It starts on 440. 442 is where I want to take you to. Scope.
This is called Aligning UK International Support for Clean Energy Transition Guidance.
Yes. Under this policy, the UK government will no longer provide new direct financial or promotional support for fossil fuel energy sector overseas. So in fact, other than in the limited circumstances outlined in this document, and align its support to enable clean energy exports. The policy applies to any new official development assistance, investment, financial and trade promotion activity overseas, including support provided by UK. The policy will also determine the UK's voting position on the boards of multilateral development banks, and that's important because the United Kingdom in this case was on the board of the African Development Bank, which voted for this finance, and be used to influence the investment policies of other development financial institutions such as CDC Group plc and Private Infrastructure Development Group that receive UK government funding, because actually there are quite a lot of these groups and bodies that provide UK government financing. This guidance defines the fossil fuel sector energy overseas as the extraction, production, transportation, refining and marketing of crude oil, natural gas or thermal coal, as well as any fossil fuel-fired plants, power plants. So it's extended this beyond what was in the CDC to include power plants. And then if you go to the next page, 444, you get the at the bottom of that page, so these are some of the exceptions, but at the bottom of the page, not allowed in italics, support for gas production, distribution and power generation, and if I can emphasize, as noted to Lord Justice Bean just now, into the global market. So that's crucial. And it's obviously important because of the vast reserves still under the earth that could still be opened up for sale. And you see that again on the next page, not allowed under B, unabated gas production, gas distribution infrastructure to the global market. So, my Lord, the government's stated position to the world is that UK financing fossil fuels would not be in alignment with its commitments under the Paris Agreement, and for that reason, it's not going to finance such projects.
This is, sorry to interrupt, this is March 21, we should know.
This is March 21, thank you.
Thank you. Yes.
So, as I already said, we say the decision, the position, the legal position and the factual position were no different when UKEF took its decision in June 2020. As Mrs. Justice Thornton says, in relation to the meaning of the Paris Agreement alignment, the government got it right in their green finance strategy, and they purported in this case to ask themselves the right question. They asked themselves, is the project compatible with the Paris Agreement, i.e. to reduce emissions well below 2 degrees Celsius with an effort to limit to 1.5 degrees? And you find that at paragraphs 269 to 70. So I'm going to turn now.
You find it where?
Core bundle, judgment. Paragraphs 269 to 70. Now I'm going to turn, my lords, to the fact that there was a dispute within government about this financing. Notably, there was a serious disagreement within government as to whether it could take place in alignment with Paris. And crucially here, bearing in mind how the case is now being put, the UK Department for International Development was against UKEF financing this project, as was the Climate Change Minister in Bays and the Foreign Secretary, all on the basis of the climate change implications, and because in their view it did not accord with the UK's commitments under the Paris Agreement and its presidency of COP26. So if I can take you first to the Secretary of State for Bays, then Alok Sharma, who was president of COP26. That's at supplementary bundle tab 44. And then the second paragraph. As you are aware, Secretary of State Truss's decision was made before our Secretary of State was cited on the material, and he has now had an opportunity to review the advice from our officials. I am writing to communicate his thoughts. In light of this advice, our Secretary of State was made aware of the Mozambique LNG proposal in his former role as Secretary of State for DFID, and that I looked up was between 2019 and 20. And was not in support when he was Secretary of State for DFID at that time. His view is that it does not seem credible to support this proposal given the UK's COP26 presidency and the Prime Minister's announcement at last year's UK-Africa Investment Summit to end UK support for thermal coal mining or coal power plants overseas, which would end direct official investment assistance, investment and export credit. Overall, the Secretary of State's view is that it is necessary to review UKEF's policy on fossil fuel investments. And then if I can take you to the Secretary of State for DFID, who was Mary Ann Trevelyan, and that's at tab 57. Now, DFID was...
So I didn't catch the page number.
Page 438. Now, DFID was tasked with the role of considering whether Mozambique complied with the OECD Sustainable Lending Principles, which is not a development assessment. It's an assessment about debt risk, effectively, and not development benefits. So starting at the third paragraph, so she notes the fact that she's got a narrow remit. Notwithstanding DFID's officials' assessment regarding the OECD Sustainable Lending Principles, I have strong reservations about the project's climate impact. In the light of the UK's very high domestic ambitions around achieving net zero, I would believe it would be more sustainable to fund other energy projects with UK companies to help UK industry to extend its capability and volume in renewable energies. We have an opportunity to strengthen UK business investment to assist countries in meeting the challenges of moving out of hydrocarbons through investments in alternative energy sources. And then it says, I acknowledge that environmental risks and impacts of UKEF projects are assessed by UKEF itself and fall outside the narrow scope of advice that my department is asked to provide to you. However, I feel it is right for Her Majesty's Treasury to consider carefully whether to support the development of such a large gas field at this time, considering the UK's commitment to promoting non-fuels fossils and reducing carbon emissions globally. And then she copies various ministers in on the next page. And then the Foreign Secretary you find at tab 41, which is page...
I can't see the copies, I'm afraid.
Sorry, it's the next page.
My next page is aligning UK international support.
You should have a list. Like it says, I'm copying this letter to the first Secretary of State, Secretary of State for Foreign and Commonwealth Affairs.
Oh, yes, got it. Sorry.
Secretary of State for Trade,
Thank you.
Business, etc., and Chief Secretary for Trade.
Generous. I thought it would be a CC.
Yes. And then page 349.
349.
This is the Foreign Secretary.
Sorry, 349.
349, Dominic Raab at the time. And he says, thank you for seeking views. I do not support proceeding with underwriting this transaction, allowing UKEF to support this facility. I recognise there are economic benefits, particularly in terms of potential jobs in the UK, attached to the Mozambique project. However, I note and agree with the concerns raised by the Secretary of State for International Development about the project's climate change impacts. The reputational risks to the UK ahead of hosting COP26 next year are considerable, not least the risk that we are seen as supporting an increased use of fossil fuels while encouraging others to move away from such investment. Now, as is plain from the submissions to the ministers, which I will take you to, the central reasons for providing the finance were as follows. First, UK contracts and jobs. Secondly, an earlier commitment, which seems to have been made before the decision was reached and may have created some legitimate expectation or binding contractual commitment. Thirdly, potential legal challenge if they pulled out at this stage. Fourthly, reputational damage and the concern of losing the chance of contracts in the Exxon Area 4 part of the project and other fossil fuel developments. Fifthly, a payment of £185 million to the Treasury and other premium revenue. And sixthly, the fact that 100% of the revenues from the project were to be generated offshore and 95% of the project risk was outside Mozambique. So it was a good bet, if you like.
So the sum of money you mentioned in point 5 was how much?
185 million. I want then briefly to take you to the submissions to the ministers. First is the submission to the first respondent, and you find that at tab 39.
Sorry, who's the first respondent?
The Secretary of State for Trade.
Bays.
No.
International trade.
International trade.
Yeah, different.
No.
No.
If it is Department for Foreign and International Development, which is now part of
No,
the Foreign Office,
FCZO.
but actually Department for International Trade, I believe, is also now in the Foreign Office. So I think all of them.
DIT.
Page 335.
Page 335.
Thank you.
And I just want to emphasise a few paragraphs. First of all, to preempt any argument by the other side, I want to emphasise paragraph 3, where it's made clear that the Secretary of State has made explicit that she wants to be consulted and decide on fossil fuel projects. So there is no delegation on this issue in the sense that she has said that she will take a final view on future fossil fuel related transactions before I use my delegated authority. And that's at paragraph 3. And then 6. This is the submission says, should you be minded against support for this transaction, you will need to set out your reasons, and I would advise these are specific to meet a level that is legally defensible. So if we say no, we need to be able to legally defend it, and that we have a chance to discuss these together. Then 13. Totals Area 1 is the first gas field to be developed, while Exxon is developing the neighbouring Area 4. Exxon has already indicated a wish to work with UKEF on its LNG project, and subject to the successful participation in Area 1, we'd expect to secure very significant further contracts. So there's a potential for further contracts if they go with this one, more than 1 billion. And then 14. For completeness and to evidence the rigour with which UKEF has considered the transaction, UKEF's business group have submitted the Environmental and Social and Human Rights Report and the Climate Change Reports. I do not believe you need to read all of these, but given concerns raised by colleagues, those are the concerns I just took you to, you may wish to pay particular attention to the Climate Change Report, effectively to be satisfied that it's compatible with the Paris Agreement obligations. And then, and that's what the Climate Change Report says. And then paragraph 17, prior to UKEF's participation, there was approximately 160 million of UK content in the transaction, and this has now increased to 360 million with an additional 370 million of UK content if in further contracts to be awarded. These are expected to be firmed up in the weeks following UKEF confirming its participation in the project. So it's already advanced a fair way.
That's in US dollars.
Yes, US dollars. 43.
Sorry, I'm being slow, I expect. How does that relate to the figure of 185?
No, 185 is pure money.
Yeah.
These are contracts.
These are contracts, yes.
43. Well, 31, perhaps just quickly look at. There's obviously concerns again. Contracts, understandable. Then 43. UK's participation is linked to approximately 1 billion of UK contracts, many of which, as explained, are in jeopardy without a UK facility being in place. At the core of all these contracts are UK contractors, suppliers and UK employees. The amount of tax they will generate and pay for the exchequer on contracts, ultimately one cannot be quantified now, but would be in the form of a range of employment and corporate taxes. And then there's an explanation of the debt financing. And you'll note in paragraph 47 that Exim's finance for the project continues to strongly support President Trump's Prosper Africa initiative to unlock opportunities for US businesses in Africa. The amendment approved today expands the scope of US involvement in the project to support even more American jobs across additional states. As was previously underscored, private financing was not available, given its size, complexity and risk, necessitating support from Exim. And by that time, the US had left the Paris Agreement. And then 52 and 53 okay, so perhaps 50. A decision to support the project will attract significant attention and scrutiny from the NGO community and adverse comment from sections of the media, and then that's blocked out. I believe the fact that UKEF has undertaken a substantive consideration of climate change matters alongside its EHSR due diligence of the project, and that these have been considered in coming to the decision to support the project. Presumably it says something along the lines means that any legal challenge will be, we will be able to resist any legal challenge or something to that effect. And then 52, if it became clear that UKEF was unable to support at this late stage for reasons not associated with the credit risk of the project, i.e., for example, Paris Agreement, there would be damage to UKEF's reputation in international exporting financing circles, stemming from a loss of trust in its ability to execute transactions. This will be particularly acute as most of the other international lenders have already agreed to lend, and this may result in the reduction in future take-up of UKEF products by overseas buyers. And then 53, this damage to reputation may be expected to go beyond the hydrocarbons sector. So there was a reputational concern. We then have the submission to the Prime Minister, which you find at page 351. And if you start at paragraph 2, arguments for and against support have led to different ministers and departments holding opposing views, although the requisite approvals from the Chancellor and Secretary of State for International Trade have been received. And then 4, agreeing support risks NGO backlash and climate-related reputational issues in the run-up to COP. There are material legal risks to a decision either way, with the likelihood of action greater if support is given, but defensibility also greater if support is given. It is considered that it would be less defensible for some reason, we don't know, to reject this finance than to grant it. And then 6, UKEF's accounting officer recommended support based on the required legal and policy factors, including UKEF's statutory purpose and climate change. So he recommended support on the basis of climate change. That's what the Prime Minister is being told. And then 7, Following the requisite approvals, this position was relayed to the project sponsors. Subsequently, BEIS, the Secretary of State, has stated opposition to the decision. It would be damaging to UKEF's and therefore Her Majesty's Government's relationships with the project sponsors, including the Government of Mozambique, if there were to be a subsequent reversal. And then 9, the project will go ahead whether UKEF provides financial support or not. However, support would increase UK content on the project from around 250 million to 730 million. And then paragraph 11, support will also bring in 185 million of UKEF risk premium to the Exchequer in this financial year, with corporate and employment taxes also payable on the UK economic activity. It's likely that material unemployment-related costs would be avoided. And then 17 to 18. From an environmental perspective, while gas is a fossil fuel, it's generally recognised as a transition fuel that's likely to displace higher polluting fuels like coal and oil, resulting in net decrease in emissions in those nations where that is the case, the UK being an example. In fact, the UK is not an example because the replacement of pipeline gas by liquid natural gas increases, not decreases, emissions. UKEF is satisfied that the project's direct emissions will be lower than those of similar projects due to the most modern technology being used, some at UKEF's requirement. However, it is not possible to assess accurately the much larger indirect emissions, since the final use of the gas cannot be known, multiple geographies and for multiple purposes, including power, domestic use and chemical production. UKEF has produced a specific climate change report considering support of the project in the context of the UK and Mozambique's Paris Agreement commitments. UKEF's accounting officer has considered its findings in coming to this recommendation to support the project. Of course, that is also wrong because it is not the case that where the gas goes affects how much carbon or GHG is emitted. It makes no difference where it goes. The only conceivable situation in which it would not be converted by a specific factor into global greenhouse gases is if it is turned into a product, which happens very rarely with liquid natural gas. So if it's actually concretized, say, into plastic.
Yes, but there may be a displacement factor, but that you say is not encompassed in that statement.
No, that's not what's said here. It said you can't actually work out.
Yeah. So that you say is plain wrong.
That's plain wrong. The reputational risk of supporting the project in the run-up to COP26 has caused the Foreign Secretary, BEIS Secretary of State and DFID Secretary of State to recommend against support. While they are aware of UKEF's recommendation is based in part on its climate change report, they have not seen that report, so they have not been reassured that this is all compatible with Paris. And nor are we aware that BEIS, DFID or the FCO have completed their own report, the implication being that had they would have concluded it was compatible with Paris. The COP26 Secretariat is similarly against support for this project. But the whole tone of this is it's all okay under Paris. And then third, the submission to the Secretary, to the second respondent, which you find at page 346. And if we can go to paragraph 1.
Sorry, I need the page.
Page 346.
So this is the 4th of June.
And this is a mandatory requirement that the Chancellor agree to it. UK Export Finance is seeking consent to provide approximately $1 billion of support for the Mozambique project. This is a fossil fuel project and therefore highly contentious. Department of Trade Secretary of State has some concerns, and DFID Secretary of State has also raised concerns about this aspect of the project. And then paragraph 2. The whole project is valued at 24.5 billion and would be transformational for Mozambique, whose GDP is 14.7. Then again, the reference to the fact that there's potential to secure further contracts in Area 4. So that's another reason that is given.
You say that's simply wrong.
No,
That it would
I
be
say it's one of the
transformational.
motivational factors. I gave you 6 motivational factors, and one of them was the fact that staying in Area 1 means that the Exxon project in Area 4 might also enable us to get contracts. I have no doubt that that was correct. And then 7.
No, I'm sorry. I was talking about it being transformational for Mozambique.
Well, it will be transformational. We just don't know quite how it will be transformational. I mean,
It's a positive comment. It's saying it would be good for Mozambique. You say not. That was the discussion we had right at the beginning.
It is highly contentious when these revenues will arrive and what will be done with them. That is not established. In any event, the finance documents show that Mozambique will not obtain revenues until the 2030s. Paragraph 7. The project is within UKEF's normal risk standards due to the reliance on non-Mozambique sponsors during construction, and as nearly 100% of the revenues will be generated offshore, UKEF has assessed that 95% of the project risk is external to Mozambique. So, because Mozambique is actually, it says it here, this allows support even though Mozambique is not routinely on cover. Because what they're concerned here is with financial decisions, not development decisions. The Treasury is being consulted because it is risking, through guarantees and loans, UK money. So its concern is to ensure that it is a good bet financially. And then 13A. UKEF has reviewed the project with regard to the potential environmental, social and human rights risks and impacts in accordance with the relevant international agreements and recent UK case law. UKEF's report on climate change risk concludes that with the actions proposed by UKEF and other lenders, the project meets the relevant international standards. It also appears, my lord, that the commitment to finance by 1.15 billion was in fact made as early as 2019, a year before the decision. And this may have been what gave rise to concerns that a decision not to provide the finance could be successfully challenged, or at the very least lead to reputational damage, since the United Kingdom was on the board of the African Development Bank and had voted for the African Development Bank to finance the project. And we find that at tab 17.
Page number?
Page 127.
Thank you.
127.
127. So you see in the box cost structure, so it's the 4th row down, you'll see the financing, and you see UKEF in the penultimate line, 3rd line up, UKEF US dollars 1.15 billion. This is July 2019. And then if we go to page 132, you see at paragraph 2.16, the co-financiers, the senior debt financing will be sourced from 18-year tenor loans from export credit agencies and a development financial institution, that's the African Development Bank, as well as 16-year tenor loans from commercial banks uncovered by the ECOs. The financing features a 5.5-year grace period for amortization. Expected loan amounts are detailed below, and then you have the UK 1.15 billion. And then if we go to page 149, you'll see at paragraph 3.4, 3.41. In the third line up, other lenders, i.e. UKEF and EKIC, have indicated they derive comfort from the bank's participation in terms of increased developmental impact monitoring and environmental oversight. So that's why they're content to do it. And this is confirmed.
Sorry, I'm so sorry, the paragraph number?
3.41 on page 149.
Yeah, thank you. Sorry.
And then this is confirmed by the underwriting minute to Mr. Taylor of 30th of June, which you find at tab 47, page 371. Paragraph 5. Following initial interest in UKEF sport in 2014, UKEF started negotiating as part of the main ECA group for the first time in February 2019. And then
So, I mean, I don't really understand why we're going into this in such detail.
we don't.
I mean,
I'm going to,
presumably it's accepted that there was a commitment of some kind in 2019, which, I mean, the briefings say that there are risks associated with not financing, having said you would before. They don't say what those risks are, and much of it is redacted, but I don't suppose it's said on the other side that there was no commitment of any kind earlier.
no, I take this only as it provides some explanation of what may have actually happened here, which was that essentially this was reverse engineering.
I mean, we're not. I'm trying to keep my focus on what this case is about and what it's not about. I mean, this case is about whether or not the government behaved unlawfully in failing to, having said it would adhere to the Paris Agreement commitments, in failing to do so. And that's the bottom line, isn't it?
Yes, my lord, and the documents I was going to take you to more, but I'm going to stop there.
I mean, leaving aside the Thameside point.
But I'll take you to one more document in relation to what the confirmation or the seeking of reassurance that this was Paris Agreement compatible. And you find that in an ERIC, which is the final committee that looks at this.
Sorry, what ERIC, what is it?
I'm going to have to look at that. I can't remember.
Well, don't worry, we can
Meaning
find
of the
it.
acronym.
We've got a list of abbreviations.
It's actually in the second supplementary bundle.
Which one?
There's supplementary bundle 2, and there are 2 ERIC minutes.
Oh, ERIC, I see.
Yeah,
Double
and
C,
it's
okay.
tab 3 and 4, and I'm going to just take you to the one at tab 4.
Sorry, we're in tab 4 of...
Tab 4 of the second SB2.
29th of May 2020, page 43.
That's right. And if you go to page 44, you'll see, and I'm afraid I can't remember the meaning of RAD either.
Well, it might be a person.
No, it's not. It is a... Oh, maybe it is. Maybe it is. Yes, it could actually. Yes, it could well be a person. RAD asks whether UKEF is consistent with wider UK government policy on climate change matters. We then have redacted, so we don't actually know what he was told. And then at 11, Eric asked whether it is possible to add an additional reference to the UK's Paris Agreement commitments on page 11 of this report. So that's the climate change report. L&C lead Eric through a discussion on, and then you get the climate change report that says it's compatible with the Paris Agreement. So, my lord, I am aware of the time. I am about 45 minutes late on my submissions. I'm going to turn to Professor Douglas to deal with interpretation of treaties and gravity.
Yes.
My Lords, I'll address you on ground 2 of the appeal, and 2 points in particular. The standard of review to apply to a challenge based on an error of law in respect to the interpretation of an unincorporated treaty, and the applicable principles for interpreting a treaty. And the 2 points are very much intertwined, because if you accept the respondent's position that the standard of review should be tenability, then it's inevitable that there will be no proper interpretation of the treaty in question. In our submission, a standard of review of legal questions based on tenability is tantamount to no review at all. And we can see this in the first instance decisions that have purported to apply tenability. There's one of 2 outcomes. The first is that there's no attempt to go through the proper methodology for interpreting a treaty. And there is only one proper methodology, my Lords, and that's in accordance with the principles in Article 31 of the Vienna Convention on the Law of Treaties. The other possibility is that the Court alludes to the standard of tenability, but then goes on to apply a correctness standard regardless. And these 2 possibilities are reflected in the judgment below. Lord Justice Stuart-Smith applied tenability and did not attempt to interpret the relevant provisions of the Paris Agreement in accordance with Article 31 of the Vienna Convention, despite recognising, my Lords, that it was mandatory. Mrs. Justice Thornton did apply Article 31 and did give a legal interpretation to the Paris Agreement. She got there by declaring that she was applying tenability, but actually, of course, she applied the correctness standard. My Lords, I'll organise my submissions around 5 propositions. The first one is that there's binding House of Lords authority to the effect that where a minister or other decision maker represents that his decision is consistent with the UK's obligations under an unincorporated treaty, then the correctness of that representation is justiciable in judicial review on the basis of an error of law. And that's the Launder line of authority, which I'll take the Court to in due course. The second proposition is that the same binding House of Lords authority, which has now been supplemented by the Supreme Court's judgment in Benker Bush, calls for a standard of correctness in review and not a standard of tenability. Third proposition, there's only one correct approach to treaty interpretation, whether it's incorporated or not incorporated in domestic law, and that's on the basis of Article 31 of the Vienna Convention. And indeed, the leading English precedents on the correct approach to treaty interpretation involve interpreting unincorporated treaties. And this is the Occidental Petroleum line of cases relating to unincorporated investment treaties. Fourth proposition is that the principle of effectiveness is a cardinal rule for the interpretation of a treaty. It's impermissible to convert a binding legal instrument with a set of defined objectives into a declaration of voluntary aspirations under the colour of interpretation. And in our submission, that was the approach of Lord Justice Stuart-Smith in the judgment below.
Was it also the approach of Lord Reid in the Heathrow case, or Lord Hodge?
No, it wasn't, my Lord, because in that case the question was all about justiciability. It had nothing to do with standard of review.
But you'll show us why paragraph 70 and 71 of that case don't damage that proposition.
Indeed I will, my Lord.
Yeah.
The fifth proposition is that the tenability standard should be rejected as inconsistent with the Launder line of authority, which is binding on this court, and also because it's an incoherent standard review for an error of law. It conflates, and this goes directly to your question, my lord, it conflates the issues relating to justiciability with the standard of review. And it introduces a notion of relative normativity at the discretion of the judge, which is antithetical to the consideration.
I'm not sure I understand that. That's all a bit complex for me. Can you simplify that?
My lord, in order to have a tenable view of something, one needs to have view of the something. One needs to take the lens cap off the camera. Justiciability decides whether or not you take the lens cap off, but once you take the lens cap off, you have a sharp image, and you take the picture in accordance with Article 31 of the Vienna Convention. The risk here, my lord, is that if you apply the low threshold of review, which the respondents are calling upon you to do, then the normative value of that treaty, which the minister has said, the decision maker has said that he's taking into account and is compatible with that treaty, the normative impact of that treaty becomes virtually non-existent. Because anything will do. You get a free pass. My lord, my first and second propositions I'll take together. The binding authority to the effect.
Might it not be that the approach that they adopt is untenable? Why is it not possible, when you're applying a tenability standard, to reach the conclusion that it's simply untenable? I presume the argument is going to be on your side that the bearing in mind all the documents we've been shown, which basically say investment in fossil fuels is not compliant with Paris Agreement, it's untenable to say it is.
Well, that's certainly our submission. But in order to get
it was also the decision that Mrs. Justice Thornton reached.
Indeed it is, and we fully endorse her reasoning. But my lords, the other difficulty with the approach adopted by Lord Justice Stuart-Smith is that there was no view taken of the Paris Agreement in reality. There was no attempt to interpret that agreement.
What, in all those pages?
In all those pages, and that is something that is quite remarkable, but in all those pages, and I'll take you to that judgment in some detail, he expressly declines to take an interpretation of the Paris Agreement. So there's no yardstick, there's no benchmark to measure any other view, because no view was taken.
My understanding of what he said, and obviously, I've only read it, but my understanding of what he said was that the Paris Agreement had a series of aspirational objectives which were not all totally consistent, and therefore you couldn't take 21C as being a hard-edged obligation. Is that not what he said?
My lord, with respect, he does consider those type of elements of the Paris Agreement, but then he gets to a conclusion where he says, as a result, I do not interpret the agreement. I'll come to those passages in due course and in some detail.
Right.
But to cover what is binding and straightforward, let's perhaps go to the first case, which is the Launder decision. This is at tab 10 of the authorities bundle. And this case, I'm sure your lordships are familiar with it, the Secretary of State for the Home Department had issued a warrant for the extradition of a British national, Mr. Launder, to Hong Kong to face trial for corruption. And the Secretary of State had said that he'd taken into account Mr. Launder's representations that his European Convention rights would be put at risk if he were to be extradited. At this point in time, of course, the European Convention was not incorporated into English law, so we're talking about an unincorporated treaty. Now, Lord Hope gave the leaving judgment, with which Lord Brown, Wilkinson, Lord Stein, Lord Clyde and Lord Hutton agreed. And if we go to page 173 of the bundle, 867 of the report, the first paragraph there sets out what I've just summarised.
Sorry, which page?
173 of the bundle. And then if we go to paragraph F, it says this, Lord Hope. if the applicant is to have an effective remedy against a decision which is flawed, because the decision maker has misdirected himself on the convention which he himself says he took into account, it must surely be right to examine the substance of the argument. The ordinary principles of judicial review permit this approach because it was to the rationality and legality of the decisions and not to some independent remedy that Mr. Vaughan directed his argument. And the legality issue, you can see set out as the first one, it was whether the Secretary of State correctly took into account the scope and content of the convention. So the issue was found to be justiciable, and the standard of review was clearly correctness. That decision was then approved shortly afterwards in the Appellant case, and this is at tab 11 of the authority bundle. And here the Director of Prosecutions had decided to consent to Mr. Appellant's prosecution for terrorism offences after considering legal advice on the new statutory provisions for such offences.
So what's the page?
I haven't got to a page yet, but 191 of the bundle will go to.
This is Appellant.
This is Appellant. And he had acted on advice that such offences were incompatible with Article 6 of the European Convention. The advice was the effect that they weren't incompatible, and so that the prosecution should go ahead. And again, this is before the European Convention had been incorporated into English law. If we could pick up the divisional court judgment, the leading judgment given by Lord Bingham, and this is at page 191, he says this is at E, "It is plain as a matter of fact that the Director did wish to know where he stood, since he would not otherwise have sought the advice of Mr. Singh. It is therefore, as it seems to me, appropriate for this Court to review the soundness of the legal advice on which the Director has made clear publicly that he relied. For if the legal advice he relied on was unsound, he should, in the public interest, have the opportunity to reconsider the confirmation of his consent on a sound legal basis. This approach is, in my judgment, consistent with that of Lord Hope, with whom the other members of the House agreed in Launder." He then quotes from Lord Hope's speech in Launder, and if we go over the page at paragraph C, it says this, "In offering such guidance as it can on the true effect of the Convention, the Court does not, in my view, usurp the legislative responsibility of Parliament, nor the independent decision-making responsibility of the Director, so long as it leaves the final decision to him." Then we go to the House of Lords judgment, page now 217 of the bundle, page 367 of the report. And you see there that Lord Stein, with whom Lord Slynn and Lord Coke...
Try Stein.
Stein, I do apologise. He agrees with Lord Bingham's judgment below and Launder. And then if we go to Lord Hope's judgment at 225...
Sorry, you were 367 where? With
that was
Lord
217. That was
217.
just to record that there was an agreement with Launder. And then we have at 225, Lord Hope's judgment. And at G, he says, among the detailed reasons which Lord Bingham gave for granting the applications of the following, and he endorses the passage that I just read to the Court. And he says this, "I respectfully agree with this observation and with the process of reasoning on which it was based. I also agree that a review of the soundness of the Director's decision would not conflict in any way with the principle of parliamentary sovereignty." And my Lords, the next case, and we probably don't need to turn it up, but just for your note, it's Barclay and Lord Chancellor, it's tab 38. It just records a concession that the respondents made in that case. It's recorded at page 2174 of the bundle in the judgment of Lord Collins, paragraph 100. And it's a concession that they're bound by Launder to accept that in circumstances where the minister has expressly indicated that the reform law in that case was compatible with convention rights, which were not applicable through the Human Rights Act in
Which
Guernsey.
paragraph of Lord Collins is, which paragraph is it?
100.
100.
So that's the concession that was made in that case based on Launder. And again, it made the issue justiciable, and the standard of review, you can see quite clearly from Lord Collins' speech, given his meticulous review of the reform law against the convention obligations, the standard of review was correctness.
He says that where exactly?
I beg your pardon?
He says that where exactly?
He doesn't say anything about the standard of review, but the standard of review he applies, and you can see this from paragraph 50 onwards, is clearly correctness. There's no question that he's undertaking some sort of tenability review to a justiciable question.
So that's back in what,
2010.
2010.
And to bring us up to date, my lords, there's then the Supreme Court's decision in Benka Bush. This is at tab 21 of the bundle. We'll go to 1131 in a moment, but just by way of introduction, this was a case where the court had to decide whether two different foreign states were entitled to claim immunity under the State Immunity Act in respect of claims by former domestic staff that were working at the respective embassies. Lord Sumption gave the judgment on behalf of the court, and he formulated the question as whether the relevant sections of the Act were consistent with a rule of customary international law which recognised the immunity in such cases. And on his approach, if there were no such customary international law rule, then those provisions of the statute would not be compatible with the right to a fair trial under the European Convention and the European Charter. So at page 1131 of the bundle, paragraph 35, Lord Sumption traces the idea of the tenability review. He says that it comes from a suggestion in Sir Philip Sales's article, and then the tentative endorsement of that view by Lord Brown in Corner House Research. And I'll return to that judgment in some detail in due course. But after recognising this support for the tenability standard, he says this at the top of page 1132, still in paragraph 35. It says this: "But I decline to treat these examples as pointing to a more general rule that the English courts should not determine points of customary international law, but only the tenability of some particular view of them. If it's necessary to decide a point of international law in order to resolve a justiciable issue, and there's an ascertainable answer, then the court is bound to supply that answer. In the present cases, the law requires us to measure sections 42b and 61a of the State Immunity Act 1978 against the requirements of customary international law, something we cannot do without deciding what those requirements are." Now, my lords, the caveat ascertainable answer in that passage was necessary because it may not always be possible to ascertain a norm of customary international law if it's asserted. That was the issue in that case, in the Benker-Bush case. But there is, by contrast, no difficulty in a case involving a treaty provision, because there can be no uncertainty as to the existence of that norm and its binding effect. So, my lords, I will move now to the third and fourth propositions, which I'll take together. And that is that in international law and in English law, there's only one approach to the interpretation of a treaty. That's to be found in Articles 31 and 32 of the Vienna Convention. And that approach also requires fidelity to the principle of effective interpretation. And the best example of the corrective approach in our submission is the English cases on the interpretation of unincorporated investment treaties when deciding challenges to arbitral awards. Now, the justiciability issue was resolved in the Occidental Petroleum case by the Court of Appeal. That's at tab 32 of the authorities bundle. I don't think we need to go there. But just in summary, the domestic foothold to interpret an unincorporated treaty was found to be the power to review the International Tribunal's decision on jurisdiction. And that's based on section 67 of the Arbitration Act. So that requires, every time you hear such a challenge, you need to interpret the unincorporated treaty. And since that case in Occidental Petroleum, there have been several English decisions that have done just that by applying Articles 31 and 32 of the Vienna Convention. So if we look at the very first case after Occidental Petroleum, to take the same approach, this is at tab 37 of the bundle. This is the Czech Republic against EMV case. And we'll go to page 2078. Paragraph 14. And here Mr. Justice Simon sets out the interpretive rules in Articles 31 and 32. The most important one is the first subsection of Article 31, general rule of interpretation. A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose. And then you see, if we scroll down a little bit, paragraph 15 at 2079, the bundle, he says this: the rules set out in Articles 31 and 32 of the Vienna Convention have been accepted by the International Court of Justice as being an accurate statement of customary international law, and English courts have applied the rules on the basis that they represent customary international law and are therefore part of English law. And then we scroll down a bit further, if we can, to 2081, paragraph 20, under the heading Object and Purpose. And if we go down a bit further, paragraph 23, this is just an example of how the object and purpose of the treaty feeds into the interpretation of the text. And he says this: the Court of Appeal in Ecuador and Occidental describe the nature of the legal relationship created and the rights generated by BITs, which are bilateral investment treaties. Under these treaties, investors are given substantive and procedural rights which may be pursued on their own right rather than by the state on their behalf. BITs give rise to consensual agreements to arbitrate between an investor and a state, arising out of but distinct from the treaty itself. In these circumstances, it seems to me plain that interpreting a BIT, the court is entitled to take into account that one of the objects of the treaty was to confer rights on an investor, including a valuable right to arbitrate. So just an example of how the object and purpose needs to be factored into the interpretation of the text. And that leads me to my fourth proposition about effective interpretation. It's a cardinal rule for the interpretation of treaties. And we see this again in another case interpreting an unincorporated treaty. It's another case interpreting an investment treaty, and that's the GPF against Poland case, tab 39 of the authorities bundle. We could pick it up at page 2192. And again, the starting point is always the same. Mr. Justice Bryan sets out Article 31 of the Vienna Convention. And if we go to paragraph 50 then, at 2193 of the bundle, he then commends Justice Simon's analysis of the correct approach to interpretation that we've just looked at, And he quotes extensively from that judgment. And then at paragraph 53, which is at 2195, Mr. Justice Bryan then focuses on the principle of effective interpretation. And he says this: the good faith interpretation principle, as set out in Article 31.1 of the Vienna Convention, brings within it the principle of effective interpretation. Under this principle, provisions of treaties are to be interpreted so as to render them effective rather than ineffective, and therefore meaningless, but without going beyond what the text of the treaty justifies. He then sets out various international authorities in support of that principle, and we've done the same in our skeleton argument, but I'll just take you to one further authority. You may not need to...
Maybe we can go to the one further authority at 2 o'clock.
That was exactly my intention. Thank you, my lord.
With 2 o'clock then.